Serial number 22, the State of Bihar versus Rajendra Ram. For the appellant, Sri Ujjwal Kumar Sinha.
My lords, this LPA is against order.
Writ petition by state.
I am appearing for the state, my lords. The order under challenge in the appeal is, my lords, dated 21/6/2017.
Inquiry matter.
Departmental proceeding.
Departmental proceeding.
My lords.
Who is appearing for? Notice has been issued to the respondent.
Lots, I am appearing lots.
You have to.
Lots.
Give the dates. What is the date of framing charge?
My lords. Yeah, जी. The charge was, my lords, framed, my lords, on 22/4/2000 and my lords,
Speak in mic, sir.
Annexure 3. Annexure 3.
Date.
22/4/2000.
22.
4/2000. April.
What was the post held by the respondent?
This was the preliminary charge whereby, my lords, he was asked to show cause.
What was the post held by him?
He was, my lords, a consolidation. ये थे चकबंदी पदाधिकारी, that consolidation, land consolidation officer.
Consolidation officer. His
Land
designation is
consolidation, yes. It is a gazetted post.
Consolidation officer.
consolidation officer.
Consolidation officer.
Actually, he was deputy collector, circle officer, lots. That post at that time he was holding.
Has he submitted his reply to the charge memo?
Yes, he
On what
submitted
date?
his reply on 22/4/2001 and not being satisfied with the reply, my lords, a departmental proceeding was initiated, my lords, by order dated 24/9/2002, Annexure 4.
Inquiry. What is the date of inquiry report?
Then, my lords, the inquiry report was submitted by the conducting officer on 11/11/2005, Annexure 9, in which, my lords, charge number 5, 6 and 8 out of 8 charges were found to be proved, and, my lords, charge number 2 and 4 partly proved, and charge number 1, 3 and 7 not proved. 5, 6, 8 proved, 2 and 4 partly proved, 1, 3, 7 not proved.
What is the date of show cause notice?
Then, my lords, show cause notice and inquiry on the basis on the inquiry report was sought, my lords, on 15/6/2006, Annexure 10. 15 June.
15/6/2015.
No, 6. 15th June 2006.
What is the date of penalty?
Annexure 10, my lords.
All right, penalty.
Then, my lords,
Is the reply?
Yes.
Is the reply?
yes. He submitted his reply on 2/8/2006. He submitted his explanation.
What is the penalty imposed?
Then, my lords, the penalty imposed is censure, which has got, my lords, only 3 years of 2 years. Only for 2 years validity. Thereafter, my lords, it goes away.
Censure.
And stoppage of 2 increments with cumulative effects. Censure and stoppage of 2 increments. 2 increments withheld with cumulative effects. That penalty order has been passed, my lords, by the government on 2/4/2007. The order of penalty has got the approval of the Chief Minister also.
So this penalty order is by government.
Yes, government.
No
Annexure.
appeal. No appeal.
Appeal he filed, that was placed before the cabinet. Cabinet rejected the appeal.
What is the date of rejection of appeal?
My lords, the punishment order is 2/4/2007,
No,
Annexure
rejection
2.
of appeal.
And the review, not appeal, he filed a review. That review was rejected on 6/2/2008. That is Annexure 1. Not an appeal, review, my lords. Review, he filed review, not appeal. Review was considered by the cabinet and it was rejected on 6/2/2008.
What is wrong with the learned single judge's order?
Now, the Honorable Single Judge, perhaps, my lords, it will be relevant to place before your lordships the charge which had been found to be proved. Because the court has held that no oral evidence was taken, just one line, no oral evidence was taken, and therefore in absence of that, or documentary, in absence of that, the charges cannot be proved and therefore is set aside. Now, my lords, my humble submission is that even if oral evidence is not taken, it will in fact depend on the nature of charge as to establish whether oral evidence is required or not. If, my lords, on the basis of documents and files and records which are
Alright.
admitted,
All right, you give an example, charge number 5,
my lords,
how it has been proved.
my lords may come to the impugned order and at internal page 4, where, my lords, the charges are enumerated in English. Otherwise, my lords, it is in Hindi. Impugned order, my lords, internal page 4. It starts from internal page 3, 1, 2, 3, 4. That is not very much relevant. 5 is proved. My lords have got it.
No, before that, where is the charge memo?
Oh, annexure. Annexure 3. Annexure 3 है. 3 के 4 है. 3 page 44. That is in Hindi. That's why
All right,
I was reading the English
all
one
right,
because
list of witnesses are there?
beg one.
List of witnesses. Along with the charge memo,
Yes.
list of witnesses.
No. There was not requirement. It is the matter which was as per the record admitted. He has disobeyed.
No, sir, but
He had disobeyed
this charge memo was issued under which rule?
under Rule 55 of
Rule?
the old rule, not the new one.
All right, show us the old rule.
CCA rules. Yes.
Huh? CCA rules 2005.
No.
Before that.
1930.
All right, give that.
अनुलग्न को है ना?
Which is the rule relating to the initiation of inquiry for major imposition of major penalty?
55.
55. No, that is penalty. I am asking you initiation of inquiry under which provision? Give it to you.
In the old rule, my lords,
Yes, old rule only. we are
there
saying.
was no detailed, my lords, procedure laid down. It is in the new rule, my lords, 2005, that detailed
Sir, all
procedure
right,
is
sir,
laid down.
from the old rule only, you point out disciplinary authority invoke which provision of law for initiation of inquiry? For framing charge under which provision of law?
That is lawsuits, Rule 167, board miscellaneous rule lawsuit. How lawsuit charge memo has to be lawsuit, drawn lawsuit in form K lawsuits.
Sir, in 1930 rules, there is no provision.
That provision was not there in 1930 lawsuit, but in 1958 lawsuit, board miscellaneous rule lawsuit, how to lawsuit prepare memo of charge in form K lawsuit, that has already been lawsuit there. Rule 167 of the board miscellaneous rule lawsuit. Even lordship in rule 55 lordship, it has been explained everything. Procedure for major penalty, rule 55.
Yes, sir. State Council, which is the provision of law which you invoked for the initiation of inquiry?
Rule 55, my lords.
No, that is in respect of penalty.
No,
No.
rule 49 is
Initiation of inquiry.
My lords, Annexure 4, that is the initiation of the departmental proceeding.
Which
it-
provision of law you have invoked?
नियमावली के नियम 55 में विहित नीति के विभागीय कार्रवाई चलाई जाए.
That is in respect of penalty.
My lords, that is all rule 55 and that is only, my lords, there. Whatever is given there, my lords, that was only there. And it was under that, my lords, that the resolution of the state government was.
penalty is lordship under clause 49 lordship, rule 49.
55 में इनिशिएट हुआ है.
55 में होता है, 55 में भी सब दिया हुआ है.
My lords, 55 says, my lords, that grounds on which it is proposed to be taken action shall be reduced in the form of definite.
Where is the
charge.
statement of allegation?
Yes, my lords, that is why, my lords, I was trying to show, my lords, that is annexure 3, page 44, and government resolution, annexure 4, page 45 of the writ. Yes.
Yes, for want of time, we'll continue tomorrow.